Hello friends, my name is Hemant Gupta and today I am going to discuss one very important point in Income Tax Act, whether a notice under section 148 can be issued in the name of deceased person. This we are going to examine in today's discussion. So I'll take the help of three sections for discussion of this topic. First is section 159, which talks about legal representative. Second is section 292B, which talks about return of income, etc. will not be valid on certain grounds. And third is section 292BB, which talks about notice deemed to be valid in certain circumstances. So with the help of these sections, we are going to analyze whether notice issued to deceased person is valid or not. Obviously, we'll also take a reference to section 148 as well. So I'll start with section 159. So section 159 talks about legal representative, which says that whenever a person dies, a legal representative shall be liable on behalf of the deceased person who would have been liable to pay the taxes. Further, this section goes on to say, for the purpose of making assessment under section 147 of Income Tax Act of deceased and for the purpose of levying any such sum in the hands of the legal representative in accordance with the provision of subsection 1, any proceeding taken against deceased person before his death, any proceeding which could have been taken against the deceased person can be taken against the legal representative, and all the provision of the act shall apply accordingly. So now, as far as any proceeding taken before the death of the deceased, that is fine. Any proceeding taken after the death of the deceased, that is also fine, that can be taken. There is no doubt about it. Now the question is whether notice served in the name of deceased person is valid or not. One could argue it's a technical defect. Assessing officer might not be knowing whether the person is alive or not. So notice must have been issued in the name of the deceased. Or so as long as the legal representative is there by virtue of section 159, who is already liable under Income Tax Act, so that person should attend to that 148 notice issued in the name of the deceased person. But this is not legally tenable. See, whenever some penal statute is there, like Income Tax Act, unless and until something written in that law, you cannot just assume or import something into that law to make it applicable. So section 148's requirement is clearly spelled in that section that notice must be served to the person. So if that person is not alive at that point, how would that notice be served on that person? That is not practically possible or legally tenable. So I'll also be reading in between from some case laws as well, so that to make this discussion worthwhile, I'll also give the link or rather citation of those case laws in the description box, so you can also refer those case laws. I'll read from one case law. Notice under section 148 of the Act is a jurisdictional notice, and existence of valid notice under section 148 is condition precedent for exercise of jurisdiction by AO to assess or reassess under section 147 of the Act. So unless and until the condition precedent is met, there cannot be any assessment under section 147. See, in one case the court held that issue of notice under section 148 in one case court held that issue of notice under section 140 of the Act is a foundation for reopening of assessment. The sine qua non for acquiring jurisdiction for reopening of an assessment is that such notice should be issued in the name of the correct person. The requirement of issue a notice to a correct person and not to a dead person is not merely a procedural requirement, but it is a condition precedent to the impugned notice being valid in law. See, what happens at times, department takes the refuge of section 292Bs. So what section 292B says is, no return of income, assessment, notice, summon or other proceeding shall be invalid merely by reason of any mistake, defect, omission in such return, assessment, notice, summon or other proceeding. So department says it's only a procedural mistake, it's only omission or defect in the notice which cannot be taken out of context, and that has to be treated as a valid service of notice. But here also at various places court have very categorically stated that issuance of notice upon a dead person and non-service of notice does not come under the ambit of mistake, defect or omission. Consequently, section 292B of the Act is not applicable to notice served upon a dead person. Further, there is one more section 292BB. At times, department also takes the refuse of this section as well. See what happens at times, the notice is served in the name of the dead person, and that notice is usually or at times complied by the legal representative, and some information or details are provided as sought in the notice, and then department takes the refuge of section 292BB. So what does section 292BB says? Where the assessee has cooperated or appeared in any proceeding under the provision of this act, so it shall be deemed that any notice which may be required to be served upon that assessee has been duly served. So department takes the refuge of this section that since he has cooperated and the legal representative has come, so for reassessment proceeding under section 147 can be taken even if there is a defect in section 148 notice. And the assessee shall be precluded from taking any objection in any proceeding under this act that notice was not served upon him, or notice was served upon him but not in time, or for that matter that notice was served upon him in an improper manner. Now just to refer to one case wherein the petitioner had merely uploaded a death certificate of the deceased assessee online and had in fact neither filed a return on behalf of the deceased person nor submitted to jurisdiction of assessing officer, and had not even waived the requirement of section 148. So assessment was being framed under section 147 against that assessee by taking the refuge of section 292BB. So what the court said was section 292BB of the act is applicable to an assessee, mind you, not to the legal representative. Further, in the present case, one of the legal heir of the deceased assessee, that is the petitioner, had neither cooperated in the assessment proceeding nor filed a return or waived requirement of section 148 or submitted to the jurisdiction of assessing officer. So she had merely uploaded one death certificate, and that is how you cannot make that person liable by taking the refuge of section 292BB. So if we talk about this issue in nutshell, the basic essence of section 148 notice is that it has to be served upon the assessee. If person is not there in the word, it cannot be served upon that person. Section 159 is there, which makes legal representative liable for deceased person, but having no notice served upon legal representative or in legal representative's name, assessment cannot be framed if the notice is issued in the name of deceased person. Now again, taking the refuge of section 292B, which talks about defects or omission or mistake in the notice, courts have very categorically said this is not a mere omission, mistake in the notice. So section 292B is also not applicable, so proceeding cannot be taken as usual. Now coming to section 292BB, where assessee cooperated during the proceeding even though the notice was not served in a proper manner, there also court has very categorically said the requirement of section 292BB is applicable to assessee and not to the legal representative. So if the assessee he himself is not there in the word, why would a legal representative be held liable for that if the department has not done their work properly? So I hope I was able to give some clarity over this aspect. In case you want to ask any more question on this topic, do let me know in the comment box. This is CA Hemant Gupta signing off. Thank you very much for watching this video.